All right, so Jackson v. Brantley really kicks off our soiree into intentional torts. Recall that in intentional torts, part of the plaintiff's case is proving that the defendant intentionally harmed them. So, you'd think that'd be pretty simple to prove, but whether or not something was intentionally done is a little more tricky than you think. So, anyway, Jackson v. Brantley is about the most Kentucky case we'll find because it involves horses. So, anyway, we're in Alabama. Um, the defendant is a farmer. His horses sneak off the farm one night into the neighbor's farm. He and his buddy go and wrangle them up. They bridle two of them. Two of them are kind of more feistier horses. They don't want to cooperate, so they're like, "Uh-oh, we can't really bridle these ones. Let's just lead them on the road unbridled." So they lead them up on the road. The plaintiff is driving one of those hot new rigs and comes around the bend, doesn't quite see the horses, or the horses get scared by the headlights. That's lost to the ages, the facts of that. And the horse gets hit by the rig. So anyway, the plaintiff sues for damages to his rig, and then the defendant counterclaims for deaths to his horse. So the big point of this case is the issue of, did the plaintiff fulfill his burden of proving that the defendant intentionally torted him, intentionally damaged his property, intentionally smashed a horse into his rig. Obviously, the defendant didn't intend to get his horse smashed against a rig, but the court still found for the plaintiff and held, yeah, you know what? The intent requirement of the tort is fulfilled. Intent doesn't mean that the defendant intended to cause the harm. Intent means that the defendant intended to do the thing that was substantially certain to result in the harm. So there was also a statute in Alabama that said don't bring your horses on the street. Also, regardless of a statute, bringing horses on a street at night, like a highway, I think it's substantially certain to assume that just by bringing horses on the highway, a rig's going to smash into one of them. So this brings us to intent in torts is one of two things. It's either that the defendant acts with the purpose of causing the consequence. So I purposefully smash a bottle over your head because you're hitting on my dog. I acted with the purpose to cause that harm. Or intent in torts is the person acts knowing that the consequence is substantially certain to result from what I'm doing. So let's put that into a real world example. I drum for Motley Crue, a cover band of Motley Crue, and you come to my show, and I am going nuts, just the best fills anyone's heard ever, and I throw my drumstick in the heat of passion out into the audience, and it nails you square in the eye. You sue me for an intentional tort. You need to prove intent. You have a good chance at winning that. Because while obviously I didn't intend to nail someone in the eye with the drumstick, my shows are so packed, so crowded, so popular, so rockin' that when I throw a drumstick out in the audience, it's substantially certain to result in someone getting hit with that drumstick. So my intent to intentionally harm you is imputed onto me for having just thrown the drumstick under those circumstances. I do have a defense available to me in this hypo called assumption of the risk. Assumption of the risk is when the person who got hurt assumed the risk. So, I shouldn't be guilty for hurting them, or I shouldn't be owing them as much money in damages because they kind of knew that the harm was going to happen. So, you come to a Motley Crue cover show, it's rocking so hard. I'd say you assumed the chance that you might get hit in the face with like a drumstick or a bottle or like a brazier or something like that. But we could change the hypo a bit and say I play in a Yanni cover band. Anyone who goes to those shows knows that they aren't rocking, so they wouldn't really assume the chance that they're going to get railed in the eye with a drumstick. Maybe a brazier, but that changes things. So what have we learned? Alabama's the sort of place that needs to write a statute telling people not to bring horses onto the highway, and even that won't stop them.